is Kenneth W. Simons, Chancellor's Professor of Law at the University of California, Irvine School of Law, to discuss the case Grimshaw versus Ford Motor Company. Welcome, Professor Simons.
Happy to be here.
So tell us about this case.
Well, the Ford Pinto case, I'd say, is probably one of the most famous tort cases in the last half century. The basic facts are that Ford manufactured the Pinto hatchback in the 1970s. In a rear-end collision, the car was arguably a fire trap. And because of the placement of the fuel tank behind the rear axle rather than above it, there was an unusually high danger that if the car was rear-ended, the car would go up in flames. Unfortunately, that's exactly what happened. A Ford Pinto stalled on the freeway, was rear-ended by another driver going around 30 miles an hour. And then in the ensuing crash, the driver suffered fatal burns and a passenger suffered very serious burns over his entire body. The plaintiffs obtained over $2 million in compensatory damages and a huge punitive damage award of $125 million, which was later reduced to $3.5 million. So that's the basic facts of the case.
So why is this, as you said, one of the most important cases in the last half century? What makes it so significant?
What makes the case so significant is the question it poses about how product manufacturers make design decisions and when they should be liable if they make them badly. So that's sort of the big picture. Let me just go into the details a little bit. In the actual case, the plaintiffs did have evidence that the Pinto had been rushed to market in an effort to build a small, inexpensive car. And a key design decision, as I mentioned, was where they placed the gas tank. They placed it where they did, behind the rear axle rather than above it, in order to save some money and contribute to this being an affordable car. But Ford also had done some crash tests prior to selling the Pinto, and those crash tests did reveal that this car was unusually susceptible to fire in a rear-end collision, and it seemed that a fix that would have protected against that increased risk of fire would only have been $2.40 per car. And a former Ford engineer testified that the decision not to make that fix was based on the cost savings. So understandably, the jury came out in favor of liability of Ford and also imposed this very large punitive damages award. And the public reaction to the case was pretty highly negative to Ford. They treated this as a case of Ford elevating corporate profits over safety. And looked at that way, it was certainly an understandable decision by the jury to award substantial damages, not just compensatory for lost wages and medical expenses and pain and suffering, but also punitive damages over and above that. So it was understandable that the jury came out the way it did. But one thing I think it's really important to think about in terms of the case is maybe we've gone a little too far in drawing the conclusion from the Ford Pinto case that it's always wrong for a product manufacturer to think about both risks and benefits, both costs and benefits, when it's deciding about how to design a product.
How so? When you say gone too far, what do you mean?
So I think they may have gone too far in the following way. I definitely agree that if a manufacturer cuts corners on a product's design just to increase corporate profits, it's appropriate they could be liable for a huge tort judgment. But I don't think the proper lesson from the case is that whenever a product manufacturer does any kind of cost-benefit analysis and decides not to make a slightly safer product, that it should always be considered to be producing a defective product. And I certainly don't think that that should always result in punitive damages. So I do understand the emotional reaction to this kind of cost-benefit or risk-benefit analysis, but I think if we think about other kinds of cases other than the extreme facts of the Ford Pinto, I think it's clear that sometimes it does seem acceptable to do some kind of a risk-benefit analysis. So let me give you an example. Suppose the plaintiff buys a subcompact car and he's injured in an accident because the car hits a patch of ice and goes off the road and into a tree. And suppose the plaintiff's able to show that if the front end of the car had been longer or if the side doors had been thicker, the plaintiff wouldn't have been injured. In other words, if the plaintiff had been driving a mid-sized car instead of a subcompact car, plaintiff would have walked away without a scratch. I don't think any court would allow the plaintiff to win in that type of case. And the reason why is here it's clearly not unreasonable to manufacture a subcompact, even though that car is clearly less safer in a collision than a larger car would be. But notice that one reason that that's not unreasonable is there's a kind of risk-benefit analysis going on. Many people want affordable cars, not more expensive large cars, or they want smaller cars, or they want cars with better gas mileage, even though they know that those cars are likely to be a little less safe. And courts do give weight to consumer preferences in products liability cases. So if consumers prefer a less safe product because it provides some kind of benefit, courts often will say that that's okay, that that doesn't make the product effective, and it certainly doesn't make the manufacturer liable for punitive damages. It might not make them liable even for compensatory damages.
So to some extent, it sounds as though you're talking about consumer expectations relative to the product.
Yeah, so I am talking about consumer expectations and consumer preferences and also consumer awareness of what the risks of a product are. So certainly one problem with the Ford Pinto is I don't think any consumers had any idea that the Pinto had this unusual susceptibility to fire damage and to catastrophic injury. And sometimes that does make a difference to courts when they look at product design issues. I mean, the clearest example in the other direction would be a sharp knife is obviously going to result in a certain number of injuries of people cutting up vegetables or opening a package. But no court would say that merely because you produce a sharp knife, you're liable for all the foreseeable damages that may result from a consumer using that. That's a really clear case where the consumer is quite aware of the risks of the product. The Ford Pinto is different because I don't think there was that level of awareness of the risks. And that's, I think, an important factor in whether a court will find that there's a defect in a product.
Does the Pinto case, Grimshaw, have continuing relevance today? And if so, why?
I'd say it still has continuing relevance insofar as its judgment that punitive damages should be awarded in the case still creates a little bit of uncertainty, I think, for corporate defendants and product manufacturers about when punitive damages would be awarded. There's a somewhat loose test adopted by the court that if you are conscious of a significant chance of injury from the way you designed your product, you can be liable for punitive damages. And there's some passages in the court's opinion in this case, the Grimshaw case, that seem to suggest merely being aware that your product is going to cause harm might subject you to punitive damages. On the facts of Ford Pinto, I think it's justifiable for there to be punitive damages because there were other really important factors. Knowledge that this was more unsafe than other car manufacturers' designs, knowledge that they could have very cheaply have avoided the harm. But again, using the example of the knife and the injuries that it foreseeably causes, I don't think we should say that punitive damages should always be allowed simply because you foresee that harm could result from the use of your product. So I think there's some risk of taking some of the language from the Grimshaw case out of context and giving it more weight than it really deserves. I think in recent years, courts have been more careful in assessing punitive damages and allowing them only in pretty outrageous cases where it's quite clear that not only that the manufacturer acted unreasonably, but they acted quite unreasonably. They were quite aware of the risks. They knew that their product was much more unsafe than comparable products. But there is some risk of taking out of context some of the language in the opinion in Grimshaw to allow punitive damages too readily across the board.
And finally, I think, what impact, if any, did the Grimshaw case have on the auto industry? Are cars safer as a result, would you say?
That's a good question. And it's a little hard to say. In the actual Grimshaw fact pattern, the National Highway Traffic Safety Administration did move forward with a very likely recall of the Ford Pinto. And before that was actually done, Ford itself decided to recall the product, and also for those cars that were already out on the market, it offered a free fix to make the product safer. Whether the ultimate result of this is safer products, it's a little hard to say. I mean, we can see with Boeing and the MAX airplane that it's had all kinds of problems with. This has not turned out to be a panacea. There are still cases where manufacturers, for maybe competitive reasons or profit reasons, rush products to the market without adequate care. So it's hard to say what the long-term result has been, but I think the National Highway Traffic Safety Administration has done a better job since then of supervising the safety of products, and there have continued to be a lot of product liability cases in which plaintiffs' lawyers have done a good job of bringing lawsuits and ensuring that safety of products is taken seriously.
Thank you very much, Professor Simons. This has been very helpful. I really appreciate it. Thank you.
Thank you.